All right, this is part two to Friday's update. It's pretty lengthy, so I figured I'd break it up and specifically talk about the arbitration for termination component today. Um, I will let you know I'll be on Chicago tonight on Monday night. I think there will be obviously an opposing opinion on that show, and we'll go from there. But we're going to continue pushing forward for union rights that everybody else in this city, as far as union protections, get to enjoy, except for our members, and why that needs to stop. Let's talk about City Council on Thursday and Chairman Rodriguez's decision to not allow me to give testimony and answer questions of the aldermen. The reality is, everything I'm going to talk about today could have been hashed out on Thursday, but he decided, and I'm guessing it came from above him, that the promise had to be revoked. So when it comes to arbitration, I just want to be very clear. This was a long process because part of it took place during phase one, well back in 2020 when we first took over. And Lightfoot's administration was very clear when it came to this proposal specifically. It was never going to see the light of day. In her administration, they never wanted to discuss it. They kept wanting to push it off. Well, here we are. Even once the arbitrator was selected and Ed Ben was the last man standing, so to speak, the city at that point knew that his decisions were very clear in the past on this topic and where it was going to go. So the Lightfoot administration kind of called an audible, and then all of a sudden from nope, a line in the sand, no way, no how, changed to police board first, arbitration second, knowing that we had the legal high ground, we had the precedent, and the Illinois statutes support our position. So as it progressed, the city still had the take it or leave it mentality under Lightfoot. That didn't really change under Mayor Johnson. As far as this provision specifically, they wouldn't budge an inch. There was several discussions about what they would need. There was never going to be, in our perspective, an open hearing at arbitration. That is not what arbitration is designed to do. And the arbitrator is pretty clear that he would never partake in that process if he was selected. So the public component, nobody else has. So we were absolutely no on that, but open to other conversations. And not even very recently, weeks now, over a month, I even let the city's team know yet again that our offer to publish the final product after the appeal process window is closed, and we know that the arbitration ruling is final once and for all, we would be open to those being posted on a city website link so people can see, with the arbitrator's name being redacted, what the decision was, what evidence was tendered, and why. That was always on the table. There were some other things on the table. It was also brought up that the charges are not public, but they are at the police board. Again, an outright lie. And I'll give deference to Anthony Driver, but I will put all the blame on Guion Foreman's lap, because he clearly and the police board were the ones that put together these talking points that are being propagated all over the place. And they're outright wrong in so many instances and misleading in others. And he has been the president of that police board for 10 years. And he is a very big reason why this provision was fought for so hard. Shame on him after all of these years to put out these outright lies, because he certainly knows better. So he's clearly lying and being deceptive. And that just goes to show you the fair shake our members won't be getting at the police board, because he's been in charge of it. So let me just highlight a couple. The charges, the way the provision reads and the award reads is the charges are still filed as they are right now. They are filed at the law department and given a number. At that point, once those charges are filed, and those are sustained complaints and charges of termination, the officer will have 10 days to file a grievance lodge a file a grievance on the officer's behalf, and either choose arbitration or continue with the police board path. That will be the officer's selection from there. But the charges are public. They are not private. So that's one lie outward right then and there. We could talk about the status of the case was another thing they were talking about. We never even discussed this with the city. They never brought up about the statuses being public, private, whatever the case may be. If we talked about the final product being published on that website link, we'd certainly have no issue with the statuses of the case, whether it's preliminary, the hearings taking place, or it's a final award. I really wouldn't give a damn if that was posted on that same website. But understand, this is still negotiations and arbitration. And at the end of the day, there has to be a little give and take. The city has never been willing to give. But we have the legal high ground in this case. We do not and never did have to give a single inch on this perspective because the statute is very clear. Now, all we did was ask for one thing in return, the freezing of the health care. And this goes to show you our argument about how the city never bargained in good faith, very frequently. So back in phase one, we asked the city that we wanted health care frozen, that we eventually wanted to get to a Philadelphia-like model where health care for active and retired officers are free. And all they did was start a new entity that was in collaboration with the union and the city and started this basically benefits office specific to law enforcement officers, which offset and cut all the red tape out and does a lot of preventive screenings and all of that stuff that ends up translating to free health care for their members. That was clearly our stated mission from day one. The city kept poo-pooing it, saying, oh, we've heard this time and time again from the lodge, et cetera, et cetera. But in phase one, we were very clear that we were going to get there and we were going to be willing to do the hard work to get there. And that meant that the initial freeze in phase one came with a $600,000 price tag from the city in order for us to conduct health screenings that can show us significant savings, that this screening process that Philadelphia hangs a lot of their hat on works flawlessly and has for decades. So the city agreed in phase one to freeze that with the expiration coming up at the end of this year. Well, the significant savings that was supposed to be shown in the data from our health screenings was to be the subject matter of the freeze continuing on into 24 and 25. The city apparently never had any intention whatsoever on ever freezing that health care, no matter what data was presented to them, because they have refused to negotiate. That is now another unfair labor practice filing at the labor board because they had an obligation that they did not meet. And also, they've already given briefings to not only the committee members, but the full council. And in that briefing, it's clearly stated that the 5% for January of 24 is really only 4.25 because they'll be getting 0.75% back from the healthcare. Again, it just highlighted the fact that they never had the intent of bargaining in good faith and having a conversation about healthcare continuing to be frozen. So that was our ask in exchange for considerations with this arbitration process. That ended all conversation. So when I hear aldermen talking about transparency and all of this good stuff, the reality is the city has been anything but transparent about what was asked. It was a very small group of people that were involved in the negotiation arbitration process. I have no idea who the running it up the flagpole terminology consisted of when Jim Franzik would talk about that. But these are proposals that we discussed lengthy. And every time we did, it came back with a let's move on. And I'll give you another example about accountability, especially when it's discipline related. A discipline matrix. This was still not decided even in this process because it's such a heavy lift. But we were the proponent of a discipline matrix. So there is a very clear, definitive discipline process for minor transgressions. The city wanted nothing to do with that. They didn't want to tackle it. Again, there was another one. It's ours or nothing. It's our way or the highway. This went on and on and on. But let's go back to this arbitration component and why it's such a problem. It is codified in labor law. There is no getting away from that. But I talked about the charges and Guion Foreman's post that the charges aren't public. That's a lie. Okay, we can have a conversation about the progress of the case as it goes on and the status is okay, fine, that was never discussed, we could add that on. But one of the other things, that the decision in arbitration is in private, absolutely. But he also says the decision with the police board is public. That's an outright lie. It's always been a lie. The police board has a hearing officer who oversees the hearing and then makes a recommendation to the board, to the full board, who deliberate in private, in closed doors, behind the scenes, and then come out and announce their decision. Nobody has any idea what is discussed amongst the police board in private. It has always been that way. So that's another outright, just bold-faced lie by Guion Foreman yet again. Should we continue? Oh, yes. Let's talk about Guion Foreman's decision to send one of our members to the full police board for a termination hearing because COPA said fire, the superintendent disagreed, and that was Superintendent Brown, mind you, and it was sent to the police board for a one person's random assignment and decision. And randomly, the president of the police board was assigned this very public case. And what did he decide? He decided the superintendent didn't meet the burden, that officer needed to be basically put in front of the police board for a full police termination hearing. And then, shortly after that decision came out, I ran into him at a women's police function and fashion show. And he knew, as soon as I saw him, I was basically on 10. And he felt the need to come over, have a conversation with me, and calm me down, and basically tell me it's going to be all right, don't worry about it. Your officer's going to be fine. Well, then what the hell did you subject him to that kind of torture for if you knew it was wrong to begin with? And there's only one explanation, because he bowed to emotional and political pressure and decided to subject one of our members to a process that he knew he should have never been subjected to and wasn't right, and that his actions were never wrong to begin with. But he still did it anyway. That, in a nutshell, ladies and gentlemen, is why the police board is a joke at this point, and why arbitration is just a fair determination of the facts with emotions taken out of the equation. Considerations, like they talk about, what Guion also put in his talking points that Anthony Driver parroted, that diversity within the makeup of the police board is quite different than the arbitrator selection list. Well, then why aren't they complaining about that, or why haven't they been complaining about that opportunity when it came to city discipline forever? Because the list of arbitrators has always been very public on who we use. They could have complained that the arbitrators need to be more diversified, but they never did until now, because it's just a nonsense argument to make, as if diversity matters about making decisions of right and wrong purely. That's all an arbitrator does. He doesn't take, or she doesn't take, any of the outside noise into consideration, because you're not supposed to. Again, it is no different than almost criminal court in that sense, that a judge is supposed to consider the facts only, not the emotions, not the screaming, not the media, not all the noise that comes attached with the police board nonsense. But that's what our officers have been subjected to, which is why the police board decisions have become so grossly imbalanced in the opposite direction, where more times than not, discipline gets upheld and terminations get upheld. And it doesn't matter about the facts of the case. And one of the other problems with the police board is the hearing officers who refuse to allow witnesses or motions to be considered. Deny, 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 deny. That is limiting our officers and this union the ability to represent its members fairly. But that's just sadly what we've been dealing with forever, and it's only gotten progressively worse. I have no explanation why my predecessors have never attacked this issue when they had the moral high ground, the legal high ground forever. I don't care why they didn't do it. We decided we were going to do it and not just talk about it, and we're putting a flag in the sand here. It's very clear. It is up to the council members to do right and vote right. This is about labor law. That's it. 100% labor law. I encourage every single member watching this video to call your alderman and make sure you get them on record, or you tell them how you expect them to vote. Because this is just one example, again, similar to COVID, where the city thinks they can just trample over collective bargaining rights and labor unions. And we are never going to tolerate being a second-tier union ever again. We are not, we never were, and onward we go. We'll see you Wednesday. Please call your alderman and share this video. Thank you.